కుర్చీ. We will shortly commence with the inaugural session. Request all our judicial officers to kindly take seats. Request to take seats from the front rows.
The Honorable Chief Justice of India is arriving. All the other dignitaries are arriving. Request you to kindly make way. ದಯವಿಟ್ಟು ಹಾದಿಯಲ್ಲಿ ಯಾರು ನಿಲ್ಲಬಾರದಾಗಿ ಕೋರಿಕೆ. ಎಲ್ಲ judicial officers, sincere request to all of you, kindly clear the way. The dignitaries are coming. So,
ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಆಗಮಿಸ್ತಾ ಇದ್ದಾರೆ.
ladies and gentlemen, I would request all of you to kindly take your seats. ದಯವಿಟ್ಟು ಎಲ್ಲರೂ ಆಸನಗಳಲ್ಲಿ ಆಸೀನರಾಗಿರಬೇಕಾಗಿ ವಿನಂತಿ. The Chief Justice of India is expected to arrive in just a couple of minutes, so I'd request all of you to kindly take your seats, please. ಯಾರು ಅನ್ಯಥಾ ಭಾವಿಸದೆ ಆಸನಗಳಲ್ಲಿ ಎಲ್ಲರೂ ಸಹ ಆಸೀನರಾಗಬೇಕಾಗಿ ಕೋರಿಕೆ.
ಇನ್ನು ಕೆಲವೇ ಕ್ಷಣಗಳಲ್ಲಿ ಕಾರ್ಯಕ್ರಮ ಆರಂಭವಾಗಲಿದೆ. ತಾವೆಲ್ಲ ದಯಮಾಡಿ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅನುವು ಮಾಡಿ.
ಈಗಾಗಲೇ ತಿಳಿಸಿರೋ ಹಾಗೆ ರಿಕ್ವೆಸ್ಟ್ ಆಲ್ ಆಫ್ ಯು ಟು ಕೈಂಡ್ಲಿ ಪುಟ್ ಯುವರ್ ಮೊಬೈಲ್ಸ್ ಇನ್ ದಿ ಸೈಲೆಂಟ್ ಮೋಡ್. ದಯಮಾಡಿ ನಿಮ್ಮ ಮೊಬೈಲ್ ಫೋನ್ಗಳನ್ನು ಸೈಲೆಂಟ್ ಮೋಡಲ್ಲಿ ಹಾಕಬೇಕಾಗಿ ವಿನಂತಿ. ಹಾಗೆಯೇ ಒನ್ಸ್ ದಿ dignitaries come onto the dais, right from the beginning till the end, we sincerely request all of you to kindly be in your seats and avoid unnecessary movement so that all of us will make this inaugural session a memorable one. There are still some more seats vacant, the green ones. Hinde irtakantoru, please occupy the seats in the front so that the judicial officers, the delegates who come in late will occupy the seat at the back and there will be no disturbance of the deliberations. ದಯವಿಟ್ಟು ಯಾರು ಅನ್ಯಥಾ ಭಾವಿಸದೆ ಮುಂದೆ ಇರತಕ್ಕಂಥ ಹಸಿರು ಚೇರುಗಳಲ್ಲಿ, ಹಸಿರು ರೆಪ್ರೆಸೆಂಟ್ಸ್ ಪ್ರಾಸ್ಪೆರಿಟಿ, ಗ್ರೀನರಿ, ಸೊ ಪ್ಲೀಸ್ ಕಮ್ ಅಂಡ್ ಆಕ್ಯುಪೈ ದಿ ಗ್ರೀನ್ ಸೀಟ್ಸ್ ಪ್ಲೀಸ್. Ladies and gentlemen, the Chief Justice of India, Honorable Shri Justice Shri Surya Kanji is here. We request the President of KSJOA, Srimati S. Nagashri, and the General Secretary, KSJOA, Shri Raghavendra Shettigar, to kindly bring the dignitaries onto the dais. Honorable Shri Justice Suryakant, Chief Justice of India, request you, sir, to please come over to the stage.
ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದಂತಹ ಶ್ರೀಯುತ ಸಿದ್ದರಾಮಯ್ಯ ಅವರಿಗೆ ವೇದಿಕೆಗೆ ಆದರಪೂರ್ವಕ ಸ್ವಾಗತ.
Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India.
Honorable Shri Justice Arvind Kumar, Judge Supreme Court of India.
And also Honorable Shri Justice Vibhu Bhakru, Chief Justice, High Court of Karnataka. Ladies and gentlemen, let's welcome the dignitaries onto the stage with a round of applause.
ಇದೀಗ ಕಾರ್ಯಕ್ರಮದ ಶುಭಾರಂಭ ನಾಡಗೀತೆಯೊಂದಿಗೆ.
Request all of you to kindly rise for Jai Bharata Jananiya Tanujate, Jai He Karnataka Mate, Nadagite.
जननीय तनुजाते जय हे कर्नाटक माते जय सुंदर नदी वनಗಳ ನಾಡೆ जय हे रस ಋಷಿಗಳ ತೀರೆ ಭೂದೇವಿಯ ಮಕುಟದ ನವಮಣಿಯೇ ಗಂಧದ ಚಂದದ ಹೊನ್ನಿನ ಗಣಿಯೇ ರಾಘವ ಮಧುಸೂದನರವ ಕಳಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ ಜನನಿಗೆ ಜೀವವು ನಿನ್ನಾವೇಶ ಹಸುವಿನ ಗಿರಿಗಳ ಸಾಲೆ ನಿನ್ನಯ ಕೊರಳಿನ ಮಾಲೆ ಕಪಿಲ ಪತಂಜಲ ಗೌತಮ ಜಿನನುತ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಶಂಕರ ರಮನುಜ ವಿದ್ಯಾರಣ್ಯ ಬಸವೇಶ್ವರ ಮಧ್ವರ ದಿವ್ಯಾರಣ್ಯ ಕಣ್ಣ ಷಡಕ್ಷರಿ ಪುಂಗ ಸಂಬಲ ಕುಮಿಪತಿ ಜನ್ನ ಕುಮಾರ ವ್ಯಾಸರ ಮಂಗಳ ಧಾಮ ಸರಿ ಕೋಗಿಲೆಗಳ ಪುಣ್ಯಾರಾಮ ಸ್ನಾನಕ ರಾಮಾನಂದ ಕಬೀರರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಕೈಲಪ ಹೊಯ್ಸಳರಾಡಿದ ನಾಡೆ ಕಂಕಣ ಜಗಣರ ನೆಚ್ಚಿನ ವೀರೆ ಕೃಷ್ಣ ಶರಾವತಿ ತುಂಗ ಕಾವೇರಿಯ ವರರಂಗ ಚೈತನ್ಯ ಪರಮಹಂಸ ವಿವೇಕರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಸರ್ವ ಜನಾಂಗದ ಶಾಂತಿಯ ತೋಟ ರಸಿಕರ ಕಂಗಳ ಸೇರುವ ಯೋಧ ಹಿಂದೂ ಕ್ರೈಸ್ತ ಮುಸಲ್ಮಾನ ಪಾರಸಿಕ ಜೈನರು ಜ್ಞಾನ ಜನಕನ ಹೋಲುವ ದೊರೆಗಳ ಧಾಮ ಕಾಯಕ ವೈಣಿಕರ ರಾಮ ಕನ್ನಡ ನುಡಿ ಕುಣಿದಾಡುವ ದೇಹ ಕನ್ನಡ ತಾಯಿಯ ಮಂಗಳ ದೇಹ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ.
ಹಾಗೆಯೇ ನಿಂತಿರಬೇಕಾಗಿ ವಿನಂತಿ. Request all of you for the patriotic song Vande Mataram.
ಮಾತರಂ ವಂದೇ ಮಾತರಂ ಸುಜಲಾಂ ಸುಫಲಾಂ ಮಲಯಜ ಶೀತಲಾಂ ಶಸ್ಯ ಶ್ಯಾಮಲಾಂ ಮಾತರಂ शोभिनी सुहासिनी सुमधुर भाषिणी सुखदां वरदां मातरं वन्दे मातरम् कोटि कोटि कंठ कल कल निनाद करले कोटि कोटि भुजै धृत कर करवाले अबला अनुमानक बोले बहुबल धारिणी नमामि तारिणी विपुदल वारिणी मातरं वन्दे मातरम् तुम्ही विद्या तुम्ही धर्म तुम्ही रिधी तुम्ही मर्म त्वं हि प्राणाः शरीरे बाहुते तुम्ही मा शक्ति हृदये तुम्ही मा भक्ति तुम्हारी प्रतिमा गढ़ी मंदिरे मंदिरे वन्दे मातरम् त्वं हि दुर्गा दश प्रहरण धारिणी कमला कमल दल विहारिणी वाणी विद्यादायिनी नमामि त्वां नमामि कमला ममला अतुला सुजला सुफला मातरम् वन्दे मातरम् श्यामलां सरलां सुस्मितां भूषितां धरणीं भरणीं मातरं वन्दे मातरम् वन्दे मातरम्
ಧನ್ಯವಾದಗಳು.
ದಯವಿಟ್ಟು ಎಲ್ಲ ಕುಳಿತುಕೊಳ್ಬೇಕಾಗಿ ವಿನಂತಿ.
ಆತ್ಮೀಯರೇ, ಈ ಹಿಂದೆ ಅಂಬೆಗಾಲುಕುತ್ತಿದ್ದಂತಹ ಹೊಸ ಕ್ಷೇತ್ರವಾದ ಕೃತಕ ಬುದ್ಧಿಮತ್ತೆ ಮಾನವ ಜೀವನದ ಪ್ರತಿ ಕ್ಷೇತ್ರದಲ್ಲೂ ಇಂದು ತ್ರಿವಿಕ್ರಮವಾಗಿ ಬೆಳೆದು ನಿಂತಿದೆ. ಒಬ್ಬ ನ್ಯಾಯಾಧೀಶರನ್ನು, ದೇಶದ ಸಮಸ್ತ ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆಯನ್ನು ಇನ್ನೂ ಹೆಚ್ಚಿನ ಕಾರ್ಯಕ್ಷಮತೆಯೊಂದಿಗೆ ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಸಹಕಾರಿಯಾಗಬಲ್ಲ ಕೃತಕ ಬುದ್ಧಿಮತ್ತೆಯ ಸಮರ್ಥ ಬಳಕೆ ಹಾಗೂ ವಿವಿಧ ಆಯಾಮಗಳ ಪರಿಚಯ ಮಾಡಿಸುವ ಸಲುವಾಗಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ನ್ಯಾಯಾಂಗ ಅಧಿಕಾರಿಗಳ ಸಂಘವು ತನ್ನ 22ನೇ ದ್ವೈವಾರ್ಷಿಕ ರಾಜ್ಯ ಮಟ್ಟದ ಸಮ್ಮೇಳನವನ್ನು ಹಮ್ಮಿಕೊಂಡಿದೆ.
Yes, indeed, ladies and gentlemen, the Karnataka State Judicial Officers Association, while organizing the 22nd Biennial State-Level Conference of Judicial Officers, has thoughtfully chosen the contemporary and forward-looking theme, reimagining the judiciary in the era of artificial intelligence. On behalf of Karnataka State Judicial Officers Association, Bengaluru, I am Shankar Prakash.
ನಾನು ವೀಣಾ ಶರ್ಮಾ.
We welcome you all to the inaugural session of the 22nd Biennial State-Level Conference of Judicial Officers. ತಮಗೆಲ್ಲರಿಗೂ ಈ ಐತಿಹಾಸಿಕ ಉದ್ಘಾಟನಾ ಸಮಾರಂಭಕ್ಕೆ ಆದರದ ಹೃತ್ಪೂರ್ವಕ ಸ್ವಾಗತ. Very hearty welcome to all of you, ladies and gentlemen.
ಇದೀಗ ಆಗಮಿಸಿರುವ ಅತಿಥಿ ಗಣ್ಯರನ್ನ, ನೆರೆದಿರುವ ಎಲ್ಲ ಸಭಾಸದರನ್ನ ಸಾಂಪ್ರದಾಯಿಕವಾಗಿ ಸ್ವಾಗತಿಸಲು KSJOAನ ಅಧ್ಯಕ್ಷರಾದಂತಹ ಶ್ರೀಮತಿ ಎಸ್ ನಾಗಶ್ರೀ ಅವರಲ್ಲಿ ಕೋರಿಕೆ.
Welcome address by Srimati S. Nagashri, the President of Karnataka State Judicial Officers Association.
A very good morning to one and all. Honorable Shri Justice Suryakant, Chief Justice of India, Honorable Shri Siddaramaiah, Chief Minister of Karnataka, Honorable Srimati Justice B.V. Nagaratna, Judge, Supreme Court of India, Honorable Shri Justice Arvind Kumar, Judge, Supreme Court of India, Honorable Shri Justice Vibhu Bakru, Chief Justice, High Court of Karnataka, Honorable Judges of the High Court of Karnataka, former Judges of the Supreme Court of India and High Court of Karnataka, Shri K. Bharat Kumar, Registrar General, Advocate General Shri Shashikiran Shetty, Registrars of the Supreme Court of India and High Court of Karnataka, distinguished delegates, members of the bar, members of the media, ladies and gentlemen. As the President of the Karnataka State Judicial Officers Association, it is my proud privilege to extend a warm and respectful welcome to all of you to the 22nd conference of our association. Our association was established on 26 October 1974, which marks a special year now. It is marvelous to feel the real profundity of the fact of 22nd Biennial State Level Conference of Judicial Officers being celebrated in the Golden Jubilee year of our association. The judicial fraternity is blessed to have the constellation of the great seers of law of the highest court of the largest democracy in the world of this momentous occasion. I deem it my singular privilege to welcome the august gathering on this red letter day. Over the past 5 decades, our association has remained steadfast in its commitment to the welfare of judicial officers and the strengthening of the justice delivery system. Today, we represent 1,129 judicial officers across the state. This gathering is not merely a conference, it is a celebration of our shared commitment to justice, integrity, and service to society. We are deeply honored to have among us today an august assembly of distinguished dignitaries, eminent jurists and leaders who have shaped and continue to shape the course of law and governance in our country. Their presence elevates this occasion into a truly memorable and momentous one. It is with great deliberation we have chosen reimagining the judiciary in the era of artificial intelligence as the theme for this conference. This choice was not incidental, it is consciously aligned with the white paper on artificial intelligence released by the Honorable Supreme Court of India, a document that marks a watershed moment in the court's engagement with emerging technology. In choosing this theme, the Karnataka State Judicial Officers Association seeks to do precisely what the white paper calls upon the judicial community to do: to understand, to deliberate, and to engage, not from the sidelines, but from the centers of the conversation. We are all the officers on whose shoulders the weight of justice delivery rests every day. It is therefore fitting that we be among the first to examine with clear eyes and informed minds what artificial intelligence means for the institution we serve. The integration of AI in the Indian judiciary is no longer a distant prospect, it is an unfolding reality. AI is already playing a supportive role in legal research, drafting, and case management. The promise is considerable. The Supreme Court's AI committee is actively charting this course with the foundational principle that AI must remain an aid to human judgment, never a substitute for it. That principle deserves to be our lodestone as well. And yet responsible enthusiasm demands that we also reckon honestly with the challenges. Globally, many nations have already embedded AI-driven legal tools into their justice systems. India is watching, learning, and rightly proceeding with both ambition and caution. Our task is to ensure that technological progress strengthens public trust in the judiciary, not erodes it. AI has the power to transform justice delivery in India in ways we are only beginning to imagine. But that transformation must be anchored in strong ethical frameworks, ones that safeguard judicial independence, uphold fundamental legal principles, and keep the human conscience at the heart of every adjudication. The complex ethical, legal, and practical questions that AI raises in the judicial context are not ones that can be resolved in a single conference. But thoughtful deliberation must begin somewhere. It begins here. It begins today. I invite each one of you to engage fully in the discussions ahead, not merely as observers of a technological tide, but as the custodians of justice who will shape how that tide is met. At this juncture, I have the honor of extending a warm welcome to our distinguished dignitaries. It is a very proud moment for all of us as His Lordship, Honorable Shri Justice Suryakant, Chief Justice of India, a judge of exceptional eminence and profound wisdom, held in the highest esteem across the legal fraternity, gracing us with his distinguished presence today. His Lordship's contributions to strengthening the rule of law and advancing judicial excellence are widely acknowledged. When His Lordship was invited to inaugurate this conference, he accepted that invitation with evident pleasure and keen interest. We are deeply grateful for His gracious presence despite His demanding schedule. It is our privilege and honor to welcome His Lordship. I welcome you, my Lord. We are equally honored to welcome Sri Siddaramaiah, Honorable Chief Minister of Karnataka, as our guest of honor. The support extended by the government of Karnataka has been invaluable in organizing this conference, sir. We extend to you a warm and hearty welcome. I extend a hearty welcome to Honorable Srimati Justice B.V. Nagaratna. Her ladyship's guidance and encouragement have been a constant source of inspiration. Madam, we are truly honored by your presence. I welcome you, madam. I cordially welcome Honorable Shri Justice Arvind Kumar, whose insights, particularly on artificial intelligence, have greatly enriched our efforts. My Lord, we are grateful for your guidance and presence. I welcome you, my Lord. I also welcome Honorable Justice Shri P.S. Narasimha, who has been very kind enough to attend this inaugural session. Thank you, my Lord, and welcome, my Lord. I also extend a most cordial welcome to Honorable Shri Justice Vibhu Bakru, Chief Justice of the High Court of Karnataka. His Lordship's leadership and invaluable support have been instrumental in the successful organization of this conference. I welcome you, my Lord. I respectfully welcome all the Honorable sitting judges of the High Court of Karnataka. Your presence adds immense dignity to this occasion. I also have the honor to welcome the Honorable Lokayukta and Upalokayukta, as well as former judges of the Supreme Court of India and the High Court of Karnataka. My warm greetings to Shri K. Bharat Kumar, Registrar General, Advocate General Shri Shashikiran Shetty, and the Registrars of the Honorable High Court of Karnataka for their continued support. I welcome Srimati Bhavani Nerle, Principal Law Secretary, Government of Karnataka, the Principal City Civil and Session Judge, the Principal District and Session Judge, Bengaluru Rural District, the Chief Judge, Court of Small Causes, Principal Judge, Family Court, the Director of the Judicial Academy, the Directors of the Karnataka Mediation Center and Arbitration Center, the Member Secretary of the Karnataka Legal Services Authority, the Registrar of Lokayukta, and all other distinguished officers. I extend my welcome to all distinguished officers and dignitaries present here today for their cooperation and participation. I welcome Sri Raghavendra Shettikar, General Secretary, and all the office bearers of our association. I extend a heartfelt welcome to all my brother and sister judicial officers whose presence makes this gathering truly meaningful. Finally, I warmly welcome all distinguished invitees and members of the print and electronic media. As we come together on this significant occasion, I am confident that our deliberations will help in shaping the future of the judiciary in India. Thank you all for your gracious presence. Jai Hind, Jai Karnataka.
ಅತಿಥಿ ಗಣ್ಯರನ್ನ ಸಭಾಸದರನ್ನ ಆತ್ಮೀಯವಾಗಿ ಸ್ವಾಗತಿಸಿದಂತಹ ಶ್ರೀಮತಿ ನಾಗಶ್ರೀ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು.
I now request the President Srimati S. Nagashri to kindly present a bouquet to the Honorable Shri Justice Suryakant, Chief Justice of India. ಅವರಿಗೆ ಪುಷ್ಪಗುಚ್ಛವನ್ನು ನೀಡಿ ಸ್ವಾಗತವನ್ನು ಕೋರಬೇಕಾಗಿ ವಿನಂತಿ. Once again, hearty welcome to you, sir.
May I request Mr. Vijayanand, Vice President, KSJOA, to present a bouquet to Honorable Chief Minister Shri Siddaramaiah.
ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯ ಅವರಿಗೆ ಹೃತ್ಪೂರ್ವಕ ಸ್ವಾಗತ ಸುಸ್ವಾಗತ. ಶ್ರೀ ವಿಜಯಾನಂದ್, ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅವರಿಂದ ಪುಷ್ಪಗುಚ್ಛ ಸಮರ್ಪಣೆ. I would request Sri Raghavendra Shettikar, the General Secretary of the Karnataka State Judicial Officers Association, to kindly welcome Honorable Srimati Justice B.V. Nagaratna, Judge, Supreme Court of India.
May I request C.K. Viresh Kumar to present a bouquet to Honorable Shri Justice Arvind Kumar, Judge, Supreme Court of India.
I would request Shri Nagarajas, the Joint Secretary, to give a bouquet to the Chief Justice, High Court of Karnataka, Honorable Shri Justice Babu. It's indeed a matter of great privilege that Honorable Shri Justice P.S. Narasimha, Judge Supreme Court of India and Chairperson of AI Committee Supreme Court of India is there. I would request Honorable Justice to kindly accept a bouquet. We also have Madam Savita Vashishji also. I would request Madam to kindly accept a bouquet from the organizing team. बहुत-बहुत स्वागत मैडम. Well, it's indeed a matter of great pride for all the judicial officers that the dignitaries have come here, and the entire association will be very pleased to felicitate the dignitaries on the dais. I would request Srimati B.S. Bharati, PDJ Dharwad, Shri J.N. Subramanya, PDJ Mandya, Srimati S. Nagashri, the President, to please felicitate Honorable Shri Justice Suryakant, Chief Justice of India.
ಭಾರತ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂತಹ ಶ್ರೀ ಸೂರ್ಯಕಾಂತ್ ಅವರಿಗೆ ಇದೀಗ ಶ್ರೀಮತಿ ಬಿ.ಎಸ್. ಭಾರತಿ, ಶ್ರೀ ಜೆ.ಎನ್. ಸುಬ್ರಹ್ಮಣ್ಯ ಹಾಗೂ ಶ್ರೀಮತಿ ಎಸ್. ನಾಗಶ್ರೀ ಪ್ರೆಸಿಡೆಂಟ್ ಇವರಿಂದ ಗೌರವ ಸಮರ್ಪಣೆ.
Thank you, sir, for accepting the felicitation. I would request Shri Nandakumar, KSJOA, Shri Basvaraj, PDJ Bengaluru, Shri Vijayanand, Vice President of the Karnataka State Judicial Officers Association, to kindly felicitate the Honorable Chief Minister of Karnataka, Shri Siddaramaiah.
ಕರ್ನಾಟಕದ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದಂತಹ ಶ್ರೀಯುತ ಸಿದ್ದರಾಮಯ್ಯ ಅವರಿಗೆ ಇದೀಗ ಗೌರವ ಸಮರ್ಪಣೆ.
I would request Srimati B.S. Rekha, PDJ Bengaluru Rural, Srimati K.G. Shanti, PDJ Ballari, Srimati Shavana Begum L. Ladkan, Member of Executive Committee, to kindly felicitate Honorable Srimati Justice B.V. Nagaratna, the Judge of Supreme Court of India.
Honorable Srimati Justice B.V. Nagaratna ಅವರಿಗೆ ಶ್ರೀಮತಿ ಬಿ.ಎಸ್. ರೇಖಾ, PDJ ಬೆಂಗಳೂರು ರೂರಲ್, ಶ್ರೀಮತಿ ಕೆ.ಜಿ. ಶಾಂತಿ, PDJ ಬಳ್ಳಾರಿ ಹಾಗೂ ಶ್ರೀಮತಿ ಶಬಾನಾ ಬೇಗಂ ಎಲ್ ಲಡ್ಕನ್, ಮೆಂಬರ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಕಮಿಟಿ ಇವರಿಂದ ಗೌರವ ಸಮರ್ಪಣೆ. ಮುಂದೆ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಶ್ರೀ ಎಂ ಭೃಂಗೇಶ್, ಚೀಫ್ ಜಡ್ಜ್ ಕೋರ್ಟ್ ಆಫ್ ಸ್ಮಾಲ್ ಕಾಸಸ್, ಶ್ರೀ ಮಾರುತಿ ಬಗಡೆ, PDJ ರಾಯಚೂರು, and Shri Jitendra Nath CS to felicitate Honorable Shri Justice Arvind Kumar, Judge Supreme Court of India.
Request the judicial officers to please come close to the stage for the felicitation. Shri M. Brungesh, Chief Judge of Court of Small Causes, Shri Maruti Bagade, PDJ Raichur, Shri Jitendra Nath CS will felicitate Honorable Shri Justice Arvind Kumar, Judge Supreme Court of India. Thank you, Honorable Shri Justice Arvind Kumar, for accepting the felicitation. And now I would request Shri Vijay Kumar Anand Shetty, PDJ Kolar, Shri K.S. Bharat Kumar, RG HCK, Shri Manohar M, Member of the Executive Committee, to kindly felicitate Honorable Shri Justice Vibhu Bakru, the Chief Justice of High Court of Karnataka. Thank you, Honorable Sri Justice Vibu Bakru, for accepting the felicitation.
Asatuma Sadgamaya, Tamasuma Jyotirgamaya. From darkness to light is the wish of knowledge-seeking Indians from times immemorial. KSJOA hopes that there will be always a kindly leading light shining to show us the right path.
Yes, ladies and gentlemen, it's now time, it's our privilege to request Honorable Sri Justice Suryakant, Chief Justice of India, to kindly inaugurate by the traditional lighting of the lamp. ಸಾಂಪ್ರದಾಯಿಕವಾಗಿ ದೀಪವನ್ನು ಬೆಳಗಿಸೋದ್ರ ಮುಖೇನ ಕಾರ್ಯಕ್ರಮದ ಉದ್ಘಾಟನೆಯನ್ನು ಗೌರವಾನ್ವಿತ ಆನರಬಲ್ ಶ್ರೀ ಜಸ್ಟಿಸ್ ಸೂರ್ಯಕಾಂತ್, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾ ಹಾಗೂ ಎಲ್ಲ ಗಣ್ಯರು ಸೇರಿ ಉದ್ಘಾಟನೆ ಮಾಡಬೇಕಾಗಿ ವಿನಂತಿ. ವಿ ರಿಕ್ವೆಸ್ಟ್ ದಿ dignitaries to kindly join in. Shri Siddaramaiah, Honorable Chief Minister, Government of Karnataka, Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India, Honorable Sri Justice Arvind Kumar, Judge Supreme Court of India, Honorable Sri Justice V.V. Bakru, Chief Justice High Court of Karnataka, Shri Raghavendra Shettigar and Srimati S. Nagashri.
ಜ್ಯೋತಿ ಬೆಳಗುವುದರ ಮುಖೇನ 2 ದಿನಗಳ ಈ ಸಮ್ಮೇಳನವನ್ನು ಉದ್ಘಾಟಿಸಿದಂತಹ ಎಲ್ಲ ಅತಿಥಿ ಮಾನ್ಯರಿಗೂ ಸಹ ನಾವು ಆಭಾರಿಯಾಗಿದ್ದೇವೆ.
The theme of the conference is both timely and necessary. Console, please reduce the volume when we are speaking. In the present technological age where artificial intelligence is transforming institutions across the world, and every sphere of governance, administration, commerce, healthcare, and education is increasingly influenced by intelligent systems capable of automation, prediction, and data-driven assistance. We once again thank all the dignitaries. At this juncture, we request the Honorable Chief Minister of Karnataka, Shri Siddaramaiah, for his address. Ladies and gentlemen, ಜೋರಾದ ಕರ್ತಾಡದೊಂದಿಗೆ ಸ್ವಾಗತಿಸಿ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಾದ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯ ಅವರನ್ನು.
Justice Suryakant ji, Honorable Chief Justice of India, Justice B.V. Nagaratna avare, Honorable Judge of the Supreme Court of India, Justice Arvind Kumar avare, Honorable Judge of the Supreme Court of India, Justice Vibhu Bakru ji, Honorable Chief Justice of High Court of Karnataka, Srimati S. Nagashri, President of Karnataka State Judicial Officers Association, Sri Raghavendra Shettigar, General Secretary, Karnataka State Judicial Officers Association, Principal District Judge, District and Session Judges, all dignitaries, senior officers, friends from the media, the ladies and gentlemen, ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. It is a privilege and honor to address this August gathering at the 22nd Biennial State Conference of Judicial Officers. I extend my warm greetings to all of you who uphold with dignity and commitment the rule of law and the constitutional values that define our republic. At a time when institutions across the world are being reshaped by unprecedented technological change, this conference on reimagining the judiciary in the era of artificial intelligence is deeply significant. We stand today at a defining juncture where law and technology are no longer separate domains but interconnected forces shaping governance, rights, and the very nature of justice itself. Artificial intelligence is emerging as a transformative force that challenges how we interpret evidence, how we understand facts, and how decisions are arrived at. It offers immense promise, aiding faster and legal research, improved case management, and the possibility of reducing pendency through intelligent systems. Yet, it also raises profound concerns. Algorithmic bias can undermine the guarantee of equality before law. Opaque systems may weaken the doctrine of reasoned decisions, which lies at the heart of our judicial process. Judicial independence, which is the cornerstone of our democracy, must be preserved not only from external pressures but also from suitable technological dependence. The authority of a judge must never be overshadowed by the authority of an algorithm. Dr. B.R. Ambedkar had reminded us that constitutional morality is not a natural sentiment, it must be activated. This cultivation requires us to ensure that constitutional values guide technological adoption, not the other way round. The emergence of artificial intelligence generated evidence presents new challenges for our legal system. Deep fakes, synthetic data, and machine-generated content compel us to revisit established doctrines relating to admissibility, burden of proof, and authenticity. The courts will increasingly be called upon to determine what constitutes reliable evidence in a digital age. In doing so, we must ensure that truth remains grounded in verifiability and integrity, not merely in technological sophistication. At the same time, the judiciary will play a defining role in shaping the regulatory framework for artificial intelligence in India. Through well-established constitutional doctrines such as due process, proportionality, and the right to privacy, our courts will determine the contours within which artificial intelligence must operate. The judiciary, there is not only user of technology, but also the ethical compass that will guide its deployment in society. Technology also offers meaningful opportunities to strengthen judicial processes. Artificial intelligence assisted legal research, democratic access to precedents, and reduce disparities in legal knowledge. Blockchain technology holds promise in ensuring secure, tamper-proof judicial records. Intelligent case management systems can streamline court functioning and reduce delays. However, these innovations must be adopted with care, ensuring that efficiency does not come to the cost of fairness. In this transformation, the capacity of our judicial institutions becomes critical. Judges of the future must be equipped not only with legal acumen, but also with a clear understanding of technological systems. The most important question before us, however, is how artificial intelligence intersects with the fundamental principles of equality and social justice. If not carefully designed and regulated, artificial intelligence systems can replicate and even amplify existing social inequalities. They can entrench biases relating to caste, class, and access, risking a form of digital social Darwinism, where existing inequalities are algorithmically reinforced, thereby undermining the very foundations of justice. Drawing from the moral foundations of Buddha's compassion and Basavana's vision of equality, our pursuit of justice must remain deeply humane and socially transformative. Dr. Ambedkar had warned us that political democracy cannot endure without social democracy. Even as we explore these new frontiers, we must remain mindful of the enduring challenges facing our judiciary. Pendency of cases continues to be a serious concern that affects timely delivery of justice. While technology can provide tools to address this, it must be implemented by systematic reforms. Though strengthening infrastructure, increasing judicial capacity, and modernizing court processes. There is also a strong and compelling need to improve accessibility to the highest court of the land. The establishment of a Supreme Court bench in South India would go a long way in ensuring justice. The role of governance in this journey is support, enable, and strengthen the judiciary while fully respecting its independence. The government of Karnataka remains committed to building robust judicial infrastructure, facilitating digital transformation, and creating an ecosystem where innovation and justice can progress together. In Karnataka, we have undertaken decisive reforms to make justice faster and more accessible, introducing time-bound case management, reducing the burden on higher courts through jurisdictional restructuring, and strengthening government litigation practices. Alongside expanding legal aid and working towards establishing more courts, our extensive legislature efforts reflect a clear commitment to building a responsive, efficient, and people-centric justice system. Additionally, our government will focus on and ensure stronger judicial infrastructure, timely filling of vacancies, access to justice in local languages, and establishment of additional specialized courts for efficient and accessible justice delivery. Governance must act as a partner in strengthening the justice delivery system, never as an encroacher upon it. As we move forward, we must never lose sight of a fundamental truth, and justice is not merely a function to be optimized, but a moral responsibility to be upheld. No algorithm can replace the human capacity of empathy, the wisdom that comes from lived experience, or the moral reasoning that defines judicial decision making. The technology can assist but cannot replace human conscience that lies at the heart of justice. This conference offers an opportunity not only to reflect on the future of the judiciary, but to shape it with clarity, responsibility, and vision. I am confident that the deliberation here will contribute meaningfully to building a judicial system that is technologically advanced, constitutionally grounded, and socially just. Thank you. Jai Hind, Jai Karnataka.
ಗಂಭೀರವಾದ ಸಮಸ್ಯೆಗಳನ್ನು ಪರಿಹರಿಸುವ ಚಿಂತನೆಗಳು ಸಮ್ಮೇಳನದಲ್ಲಿ ಮೂಡಿಬರಲಿ ಎಂದು ಆಶಿಸಿದಂತಹ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು.
ಧನ್ಯವಾದಗಳು ಸರ್. I would now request the Chief Justice of High Court of Karnataka, Honorable Shri Justice Vibhu Bakruji, for the presidential address. Ladies and gentlemen, ಸ್ವಾಗತಿಸಿ Honorable Shri Justice Vibhu Bakru.
Justice Shri Shurikant, Honorable Chief Justice of India and Mrs. Vashisht, Shri Siddaramaya ji, Honorable Chief Minister, Government of Karnataka, Justice B.V. Nagaratna, Judge, Supreme Court of India, Justice P.S. Narasimha, Judge, Supreme Court of India, Justice Arvind Kumar, Judge, Supreme Court of India, my brother and sister judges from the Karnataka High Court, Srimati Nagashri, President, Mr. Raghavendra Shettigar, General Secretary, and other office bearers of the Karnataka State Judicial Officers Association, all judicial officers of the state, ladies and gentlemen. Good morning to all of you. It's a privilege to be present here at the inauguration of the 22nd Biennial State-Level Conference of Judicial Officers. This conference is not merely a formal gathering. It is, in many ways, a moment of collective reflection, a pause in our demanding schedules to think, to reassess, and to reimagine the future of our institution. The theme chosen for this conference, that is reimagining the judiciary in the era of artificial intelligence, is both contemporary and compelling. It calls upon us to engage with the reality that it is no longer a distance or theoretical, but immediate and transformative. We are living in times where technology is not just assisting human activity, it is reshaping it. Artificial intelligence has moved beyond laboratories and entered into courtrooms, offices, and our daily lives. We in Karnataka State Judiciary stand at a pivotal stage of transformation. Digitization is no longer a buzzword. It is to be the backbone of how we learn, work, and serve. By embracing data-driven decisions and insights, we unlock speed, resilience, and inclusion. Yet, technology alone is not the strategy. People are. We must invest in skills, redesign processes, and ensure security and privacy and uphold the ethics. In Karnataka, the initiative to digitize records, move to e-filing, and creating a paperless work environment has picked up some traction, but we are as yet at the beginning. We need to commit ourselves wholeheartedly to adapting and improving the pace of digitization. Collaboration across teams will turn tools into outcomes and ideas into impact. Together, we have to modernize with purpose, measure what matters, and build a work environment that is smarter and possibly fairer. In Bengaluru, we ran out of storage and filing space some time ago. Accessing files has become a task. However, we are addressing this problem. We are setting up a 140,000 square feet facility at Anikal for scanning, sorting, and managing files. This is a huge task, but at the end, we will have a more efficient system of accessing our files. The Supreme Court has issued a white paper on the use of AI, and we must actively examine how we can enhance our capabilities using AI in areas such as scrutiny of filings, case management, bunching of matters, and listing. The question before us is not whether we should engage with artificial intelligence. The real question is how we should engage with it. The judiciary is and must always remain a human institution. The administration of justice is not a mechanical process. It is not an algorithm. It is not a mere application of rules to facts. It's a deeply human exercise, one that requires judgment, wisdom, experience, and above all, a sense of fairness. As of yet, no machine can replicate empathy, no algorithm can replace conscience, and no software can substitute judicial wisdom. And therefore, as we speak of artificial intelligence, we must be clear that it is a tool. A powerful tool, no doubt, but only a tool. As I said earlier, the way we can use this tool is engaging. Like any other technology, it must be used to the extent that it leads to efficiency. It is not an end in itself. In this context, the Judicial Transfer Management System, JTMS, which was developed under the broader E-Committee initiatives, deserves some mention. It represents a simple yet successful digital reform in judicial administration. By introducing a structured, transparent, and technology-driven mechanism for posting and transfer of judicial officers, JTMS has significantly enhanced efficiency and accountability. The transfer list of judicial officers, which you all know, was released day before yesterday. Well, I can tell you that all transfers were the result of a matrix run through software. Not a single transfer has been made on any other consideration. It is all based on the reference norms fed into the software, which really is a mix of the officers' preferences, their seniority, the exclusion of the zones which they have worked in and where they were posted. The transfer committee and the full court made no exception. I'm also acutely aware of the workload that you're bearing due to vacancies, but that will be substantially addressed shortly. The recruitment process for judges, which started in July, is culminated in selection of 83 judges. Their appointments are now being processed, and we have already started the process of recruitment for the remaining vacancies. The process of filling existing vacancies is a critical step towards reducing pendency and ensuring timely delivery of justice, which remains at the heart of our institutional commitment. Equally significant are the steps taken for strengthening judicial infrastructure. The grant of 4.5 acres of land at Nagaratna by the state government would address the issue of housing for the High Court judges. Further, the space provided at Kaveri Bhavan will serve as an annexee to the High Court building. This should, to some extent, ease space constraints and help create a more conducive and efficient working environment for the institution. The alternate dispute resolution methods would serve as a force multiplier in addressing pendency. We must be perceptive to these options for expanding our capacity. The Karnataka Arbitration Center, which was operating from a space about 12,000 square feet and had begun to look more like a filings storage area, has been revamped. The state government has handed over possession of an additional 23,000 square feet. The center is being modernized, and now all filings would be done electronically. The capacity of the mediation center at Bengaluru is also being enhanced, and small centers are being operationalized at district and taluk levels, as you all know. These measures taken together reflect a sustained and multidimensional effort to strengthen the institutional capacity of the judiciary, both in terms of human resources and infrastructure. As I said at the outset, we are at the pivotal point of transformation. The future isn't arriving to us, we are building it. To the judicial officers, I say that at the center of this transformation is each one of you. You are the backbone of the justice delivery system. You are the first point of contact for litigants. You are the face of the judiciary for countless citizens. As we move into an era shaped by technology, your role becomes even more significant. You must be willing to learn, you must be open to change, but at the same time, you must remain firmly rooted in the judiciary's core values: independence, impartiality, integrity, and compassion. These are not negotiable. These are not replaceable. These are the very foundations upon which public trust in judiciary rests. Our Constitution envisions a justice system that is accessible and fair. Technology must serve this vision. It must not create new barriers. It must not deepen inequalities. It must not distance the judiciary from the people. Ultimately, the success of any reform, technological or otherwise, must be measured by one standard. Does it bring justice closer to the common citizen? As we inaugurate this conference today, I urge all of you to actively participate in the deliberations, share your experiences, discuss your challenges, exchange ideas, and most importantly, think collectively about how we can shape a judiciary that is future-ready, yet firmly anchored in its values. This conference is an opportunity not just to discuss artificial intelligence, but to reflect on the kind of judiciary we want to build for the coming generations. With these thoughts, I conclude my address. It gives me great pleasure to be a part of the 22nd Biennial State-Level Conference for Judicial Officers. Thank you. Jai Hind. Jai Karnataka.
Well, ladies and gentlemen, the judiciary in Karnataka has emerged as one of the most progressive judicial systems in India in embracing technology, of course, while maintaining judicial caution. Thank you very much, Honorable Chief Justice Vibhu Bakruji, Chief Justice, High Court of Karnataka. ಧನ್ಯವಾದಗಳು ಸರ್.
ಆತ್ಮೀಯರೇ, ಪ್ರಜೆಗಳಿಗೆ ನೀಡಲ್ಪಟ್ಟ ಎಲ್ಲ ಸಾಂವಿಧಾನಿಕ ಹಕ್ಕುಗಳು ಸ್ವಾಯತ್ತವೂ ಸ್ವತಂತ್ರವೂ ಆದ ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆ ಇಲ್ಲದಿದ್ದರೆ ತನ್ನ ಅರ್ಥವನ್ನೇ ಕಳೆದುಕೊಂಡು ಬಿಡುತ್ತದೆ ಅಂದವನು ಆಂಡ್ರೂ ಜಾಕ್ಸನ್. ಇದೀಗ may I request Honorable Chief Justice Arvind Kumar, Judge Supreme Court of India, to address the August gathering. Sir, please.
ಬಂಧುಗಳೇ, ಸ್ವಾಗತಿಸಿ Honorable Chief Justice Arvind Kumar.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಶ್ರೀ ಜಸ್ಟಿಸ್ ಸೂರ್ಯಕಾಂತ್, Honorable Chief Justice of India, Madam Savita Suryakanji, my esteemed sister Justice Nagaratna, my esteemed brother Justice Narsimha, Judges, Supreme Court of India, Shri Siddaramaiah, Chief Minister, Government of Karnataka, Shri Vibhu Bakru, Chief Justice, High Court of Karnataka, my esteemed brother and sister judges of High Court of Karnataka, former judges of High Court of Karnataka, Shri Shashikiran Shetty, Learned Advocate General, Government of Karnataka, Shri Arvind Kamath, Additional Solicitor General of India, Shri Shanti Bhushan, Learned Deputy Solicitor General of India, Srimati Nagashri, President, Shri Raghavendra Shettigar, General Secretary, and other office bearers of the Karnataka State Judicial Officers Association, all the learned registrars of High Court of Karnataka, and my dear learned judicial officers of the state of Karnataka, staff of the judiciary, friends from print and electronic media, ladies and gentlemen. When one speaks to judicial officers, it is often in the language of pendency of cases, vacancies, infrastructure deficits, administrative strain, and rising expectations. All of these are real and none can be ignored. Yet today, I believe it is equally important to being in the language of recognition. The latest Justice report published by the Supreme Court of India places Karnataka as first among the large and mid-sized states in justice delivery system. This position rests on broad institutional strength. The same report identifies Karnataka as the only state, I am stressing, as the only state to meet scheduled castes, scheduled tribes, and other backward classes community quotas in the judiciary. These are not ornamental distinctions. They are measurable indicators of institutional seriousness, and they reflect sustained work system to which our judicial officers of Karnataka state have made a substantial contribution. The achievements should be acknowledged with clarity. My Lord, the Chief Justice of India, I would like to place on record the statistics for the last 3 years, which speaks for itself, both in the High Court and in the District Court. 2023, I'll just give one example. Total cases instituted is 1,12,473, disposed of is 98,668. That is case clearance rate 83.82. The combined cases instituted for 3 years is 3,70,450 and disposed of is 3,11,037. That is the case clearance rate is 83.97% in Karnataka High Court. In district judiciary, if for the last 3 years, if the statistics is taken, the total number of cases instituted is 60,31,273 and 57,56,568 cases have been disposed of. That is 95.45% of the cases. That is why we the Karnataka district judiciary stands first in the entire country. If we just have a cursory look with regard to the statistics of the Legal Service Authority, I take pride in bringing to the notice of the Honorable CJI that state of Karnataka has been rated first in legal aid by the India Justice Report. I would like to share that in the last 3 Lok Adalats held from 2024 July to 30th June 25, 1 crore 56 lakh 520 cases have been settled in National Lok Adalat throughout the state, and the entire credit goes to our judicial officers who are present here today. Likewise, the Karnataka Mediation Center has recorded a significant progress. Overall, the center has achieved a success ratio of 61%. On technical front, the High Court has taken up a project for implementation of computer network upgradation. A platform has been provided by the High Court, that is online digital case diary for advocates, litigants and government departments, so that they can profile their cases across the state in the form of a dashboard, enabling digital tracking and eliminating paper-based case diaries. Steps have been taken to leverage AI in key use of case to advance the agenda of ease of doing business. The civil court database of the district judiciary has been integrated with the state land records, like the projects called E-Asti, E-Swattu and Bhumi project, which provides the prospective buyers and investors about awareness of litigation status and sub judice matters relating to properties. Apart from starting various initiatives, Karnataka judiciary and our judicial officers have every reason to take pride in what they have built. The statistics I have referred to must not become a point of rest. They must become a point of resolve. The natural ambition is to strive to become first in the judiciary pillar itself, and I hope and trust that this can be achieved under the guidance of our Honorable Chief Justice of India. Success in an institution such as ours is never an invitation to complacency. It is an invitation to deepen excellence. My Lord, the Honorable Chief Justice of India, with your permission, I would like to switch over to Kannada for few paragraphs so that it will directly appeal to the Honorable Chief Minister who is present here today. ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳೇ, ಕರ್ನಾಟಕ ರಾಜ್ಯದ ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆಗೆ ತಮ್ಮ ಸಹಕಾರವನ್ನು ನೀಡುತ್ತಿರುವುದು ಶ್ಲಾಘನೀಯ. ನ್ಯಾಯಾಂಗಗಳ ಕಟ್ಟಡಕ್ಕೆ ಮತ್ತು ನ್ಯಾಯಾಧೀಶರ ನಿವಾಸಗಳು ವಿವಿಧ ಜಿಲ್ಲೆಗಳಲ್ಲಿ ಸ್ಥಾಪಿಸುವುದು ಅತ್ಯವಶ್ಯಕ. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳುಹಿಸಿದಾಗ ಮಂದಗತಿಯಲ್ಲಿ ಅದರ ಬಗ್ಗೆ ರಾಜ್ಯ ಸರ್ಕಾರದ ಅಧಿಕಾರಿಗಳು ಸುಮಾರು ಬಾರಿ ಗಮನ ಹರಿಸಿರುತ್ತಾರೆ. ನಾವು ಈಗಾಗಲೇ ಹೇಳಿರುವಂತೆ ವರ್ಷಂಪ್ರತಿ ವ್ಯಾಜ್ಯಗಳು ದಾಖಲಾಗುತ್ತಿರುವುದು ಹೆಚ್ಚಾಗುತ್ತಿದೆ. ಪ್ರತಿ ವರ್ಷ 23ರಲ್ಲಿ 17 ಲಕ್ಷ ಇದ್ದಿದ್ದು 25ರಲ್ಲಿ 22 ಲಕ್ಷ ಆಗಿದೆ. ಹೊಸ ಕಾನೂನುಗಳು ಮಂಡನೆ ಆಗುತ್ತಿದೆ ಮತ್ತು ಆ ಕಾನೂನು ಅಡಿಯಲ್ಲಿ ನ್ಯಾಯ ವಿತರಣೆ ಮಾಡಬೇಕಾಗುತ್ತದೆ. ಆದರೆ ಇದೇ ಕಾಲದಲ್ಲಿ ಮೌಲ್ಯ ಸೌಕರ್ಯಗಳ ಬಗ್ಗೆ, ನ್ಯಾಯಾಧೀಶರುಗಳನ್ನು ನೇಮಕಗೊಳಿಸುವ ಬಗ್ಗೆ, ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಗಳನ್ನು ನೇಮಕಗೊಳಿಸುವ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯಗಳು ಇತರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳುಹಿಸಿದಾಗ ತಮ್ಮ ಅಧಿಕಾರಿಗಳು ಮಂದಗತಿಯಲ್ಲಿ ಅಥವಾ ಕೆಲವು ಬಾರಿ ಅದರ ಬಗ್ಗೆ ಗಮನ ಹರಿಸದೆ ಬೇಡಿಕೆಗಳನ್ನು ಕಡಿತಗೊಳಿಸಿ ಅನುಮೋದಿಸಿರುವ ಉದಾಹರಣೆಗಳು ಬೇಕಾದಷ್ಟು ಇವೆ. ಕಳೆದ 2 ವರ್ಷಗಳಲ್ಲಿ ಬೆಂಗಳೂರು, ಕಲಬುರಗಿ ಹಾಗೂ ಧಾರವಾಡ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಗಳ 666 ಹುದ್ದೆಗಳನ್ನು ಅನುಮೋದನೆಗಾಗಿ ಕೇಳಿದ ಮೇರೆಗೆ ತಮ್ಮ ಅಧಿಕಾರಿಗಳು 238 ಹುದ್ದೆಗಳನ್ನು ಮಾತ್ರ ಅನುಮೋದಿಸಿರುತ್ತಾರೆ. ಇದೇ ರೀತಿಯಾಗಿ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯಗಳಿಗೆ 680 ಹುದ್ದೆಗಳ ಅವಶ್ಯಕತೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಮಂಡಿಸಿದಾಗ ಕೇವಲ 400 ಹುದ್ದೆಗಳನ್ನು ಅನುಮೋದಿಸಿರುತ್ತಾರೆ. ಕಳೆದ 3 ವರ್ಷಗಳಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಮತ್ತು ಜಿಲ್ಲಾ ನ್ಯಾಯಾಲಯಗಳು ವತಿಯಿಂದ ಒಟ್ಟು ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ನಾವು ಅಂದರೆ ನ್ಯಾಯಾಂಗದ ವ್ಯವಸ್ಥೆಯ ಮುಖಾಂತರ ವಸೂಲಾತಿಯಾದ ಕೋರ್ಟ್ ಫೀ, ಪೆನಾಲ್ಟಿ, ಸ್ಟ್ಯಾಂಪ್ ಡ್ಯೂಟಿ ಬಿಟ್ಟು ಒಟ್ಟು 3 ವರ್ಷದ್ದು 23-24 376 ಕೋಟಿ, 24-25 439 ಕೋಟಿ, 25-26 470 ಕೋಟಿ. ಸಿಬ್ಬಂದಿ ವರ್ಗಕ್ಕೆ ಸಂಬಳ ಅಲ್ಲದೆ ಬೇರೆ ಖರ್ಚಿನ ವೆಚ್ಚ ಸರ್ಕಾರವು ಕೊಟ್ಟಿರುವುದು 1,03,00,000, 40 ಲಕ್ಷ, 137 ಲಕ್ಷ, 141 ಲಕ್ಷ. Chief, what I am highlighting is by way of fine, duty, penalty, what the courts have collected for the last 3 years is 376 crores, 439 crores and 470 crores. By way of other than the salary, non-expenditure, what has been given by the state government is 103 lakhs, 40 lakhs, 137 lakhs, 141 lakhs. That means it is peanuts. So what the proposal we send is, please give the money which we have collected at least to the extent of 75% or 80%. ಈ ಅಂಕಿಅಂಶಗಳನ್ನು ನಾವು ನ್ಯಾಯಗಳ ವತಿಯಿಂದ ವಸೂಲಿ ಮಾಡಿರುವ ಕೋರ್ಟ್ ಫೀ ಮತ್ತು ಇತರೆ ಮೊತ್ತದಲ್ಲಿ ಹೋಲಿಸಿದಾಗ ಸರ್ಕಾರವು ನ್ಯಾಯಾಲಯದ ಅಭಿವೃದ್ಧಿಗೆ ಕೊಟ್ಟಿರುವ ಹಣವು ಅತ್ಯಂತ ಕಡಿಮೆ ಆಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಿಂದ ಬರುವ ಪ್ರಸ್ತಾವನೆಗಳನ್ನು ಕಡಿತಗೊಳಿಸದೆ ತ್ವರಿತವಾಗಿ ಅನುಮೋದಿಸಲು ತಾವು ಖಂಡಿತವಾಗಿ ನಿರ್ದೇಶನ ಈ ಕೂಡಲೇ ಕೊಡುತ್ತೀರಾ ಎಂದು ಆಶಾಭಾವದೊಂದಿಗೆ ಇರುತ್ತೇನೆ. ಹಾಗೆ ಆಗಿದ್ದಲ್ಲಿ ನಮ್ಮ ನ್ಯಾಯಾಧೀಶರುಗಳು ಈ ಕರ್ನಾಟಕ ರಾಜ್ಯವನ್ನು ಮಾದರಿ ರಾಜ್ಯವನ್ನಾಗಿ ಮಾಡುವುದರಲ್ಲಿ ಯಾವುದೇ ಸಂದೇಹ ಇರುವುದಿಲ್ಲ. There is, if I may say so, a recurring weakness in institutional administration in this country. The assumption that what is evolved in Delhi is necessarily fit to be prescribed to the rest of India. That assumption is misplaced. Delhi is equally important, but Delhi is not the measure of India. What may appear efficient in Delhi may, when mechanically transported elsewhere, prove unsettling, alien, and even counterproductive. Judicial institutions do not become stronger when they are asked to imitate reflexes that are not their own. Karnataka does not need borrowed habits of authority. It does not need reform by administrative overrun. It needs reform that understands its own traditions, respects its own bar, trusts the experience of its own district judiciary, and proceeds by consultation, calibration, and institutional ownership. Change imposed from above may produce compliance for a time, but it rarely produces conviction. Durable reform comes only when it grows from within the institution itself. Karnataka has earned its standing through rooted and sustained labor, not by mimicry, and its future will be secured not by transplantation of another court's culture, but by confidence in its own. It's a privilege to be present at this conference of judicial officers gathered around a theme of deep contemporary relevance, reimagining the judiciary in the era of artificial intelligence. At a time when institutions across the world are being compelled to rethink how they function, it is only fitting that judiciary to reflect with care and confidence and on how it must evolve, remaining faithful to its constitutional character. Technology is no longer optional to the administration of justice. The real question is not whether the judiciary should engage with technology, but how it should do so. My answer is simple. Technology must not replace adjudication. It must remove friction around adjudication. It should help court organize records better, retrieve information faster, reduce clerical delay, improve scheduling, support translation and transcription, and strengthen the efficiency and transparency of judicial offices. It should protect judicial time for judicial work. Artificial intelligence may assist in the management of information, but it cannot substitute the judicial mind. No machine can hear with conscience, weigh fairness, or bear constitutional responsibility. The judge remains central. Technology must remain instrumental. For Karnataka, the path ahead is therefore both clear and achievable. The task is not to create excellence from nothing. It is to elevate an already high-performing system. The task is to reduce old case pendency with enhanced techniques, improve case clearance rates with greater consistency, strengthen office-side efficiency, and use technology intelligently to make administration lighter, quicker, and more reliable. Karnataka is not beginning from weakness. It is beginning from strength. That is precisely why this is a moment not merely for satisfaction, but for ambition. I therefore appeal to the judicial officers of Karnataka that statistics before us should not be read merely as a report card. They should be read as a statement of trust. They show that Karnataka has already emerged as one of the strongest justice systems in the country. They also show that even greater heights remain within reach. If this institution combines discipline with imagination, data with judgment, technology with restraint, and reform with rootedness, there is no reason why Karnataka should not move from being first overall to becoming the foremost judicial system in the country as well. That is a goal worthy of this institution, worthy of this state, and worthy of the confidence that the citizens repose in the judiciary every single day. I am confident that our judicial officers would leave no stone unturned to achieve this. I congratulate the Judicial Officers Association for having taken great pains in organizing this 22nd Biennial Conference and choosing this right subject for which we will be receiving guidance from the Honorable Chief Justice of India and also my esteemed sister Nagaratna, who have been striving very hard to elevate the status of judiciary in all forms, and my brother Justice P.S. Narasimha would also be delivering his erudite special address on the subject integrating, institutionalizing and regulating artificial intelligence in judicial process, which will not only throw light on improving the quality of justice delivery, but also guide our judicial officers in that regard. I wish this conference all the success. Jai Hind, Jai Karnataka.
ಕರ್ನಾಟಕ ನ್ಯಾಯಾಂಗದ ಸಾಧನೆಯನ್ನು ಸಭಿಕರೊಂದಿಗೆ ಹಂಚಿಕೊಂಡಂತಹ ಗೌರವಾನ್ವಿತ ಶ್ರೀ ನ್ಯಾಯಮೂರ್ತಿ ಅರವಿಂದ್ ಕುಮಾರ್ ಸರ್ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು.
We now request Honorable Srimati Justice B.V. Nagaratna, Madam, Judge Supreme Court of India, for her address. ಬಂಧುಗಳೇ, ಸ್ವಾಗತಿಸಿ Honorable Srimati Justice B.V. Nagaratna.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. A very good morning to everybody. Honorable the Chief Justice of India, Sri Surya Kantji, who has been leading the Indian judiciary with his vast experience, dynamic leadership and wisdom. Srimati Savita Vashisht Suryakant, the lady behind the powerful Chief Justice. Sri Siddaramaiah, Honorable Chief Minister, Government of Karnataka, my esteemed brother and sister judges of the Supreme Court, Justice Narasimha and Justice Arvind Kumar, Chief Justice Vibhu Bhakru, Chief Justice High Court of Karnataka, my brother and sister judges of the High Court of Karnataka, both sitting and retired, Learned Advocate General Sri Shetty, Learned ASG Sri Kamath, and the officers of the Union of India who are representing in the High Court, Srimati S. Nagashri, President, Karnataka State Judicial Officers Association, Sri Raghavendra Shettigar, the General Secretary and other office bearers, the esteemed panelists who have come from Delhi and other places, brother and sister judges of the District Judiciary, learned senior advocates and advocates, distinguished invitees, members of the media, ladies and gentlemen. I thank you all for once again inviting me to the 22nd Biennial State Level Conference of Judicial Officers on the theme, Reimagining the Judiciary in the Era of Artificial Intelligence. I thank the KSJOA and congratulate them on this Golden Jubilee year. I stand before the judicial officers of Karnataka today with immense feeling of pride. I have deep respect for the work you do every single day. You are the face of justice for thousands of litigants in the state of Karnataka. For most citizens, their interface with justice, fairness, and rule of law begins and ends in your courtrooms only. Every day you walk into your courtrooms not just with files on your dais, but responsibilities that are very heavy. You listen to stories of broken families, lost livelihoods, disputes over land, and sometimes deeply painful accounts of crime and suffering. Yet, despite the pressure, the workload, and the constraints, you continue to uphold the law with patience and commitment. The judges in India are the most overburdened judges in the world, and yet justice continues to be alive in this country. This is because of the dedication, particularly of the judges of the District Judiciary. My Lord, the Chief Justice of India, I have immense pride in saying that the District Judiciary in Karnataka is one of the best, and I thank you for accepting our invitation to be here today. It is in this context that I wish to say a few words about artificial intelligence or AI, since that is the theme of this conference. But let me begin by clarifying something very important. AI is not about replacing judges, and it is certainly not about machines deciding cases. It is only a tool that can support you, reduce your burden, and make the system more efficient. But importantly, AI does not think like a human. It does not understand justice, fairness, or morality. It only processes data and gives output based on what it has seen before. Artificial intelligence at its simplest is just a tool. It is not a thinking being, it is not a judge, and it surely does not possess wisdom or values that a judge possesses. It does not replace human judgment, it is only assisting human work. The first and perhaps the most immediate area in which AI may be used is at the stage of filing and scrutiny of cases. This does not eliminate human scrutiny, but it only reduces repetitive errors and saves time at the very beginning of the process. Another area where AI can be deployed is in case listing. For example, it may reveal that certain categories of cases consistently get delayed at a particular stage. Based on this, it can suggest small but meaningful changes in scheduling of cases. In fact, I think the summer holidays must be made use of so that the cases are scheduled in such a way that the long cause list which is there before the judges in the district judiciary or before the High Court are scheduled in such a way that ultimately the judge is able to take up most of the cases, if not all. The system of giving of dates should be such that where we can take the help of AI so that the stages which are lengthy, such as cross-examination or a final argument in the district judiciary or a final argument in the High Court, they should be spread out in such a way that ultimately the case is taken up and a date is not just given. When it comes to legal research, AI can be particularly valuable. Importantly, such systems can also highlight conflicting precedents or recent position of law on the point. To be sure, it does not replace legal analysis or human oversight, but it ensures that the judge has a more comprehensive set of materials before making a decision. At a broader level, AI can support the functioning of legal aid systems too. With all of this means, in practical terms, that the time and energy that judges currently spend on repetitive and time-consuming tasks could be reduced. In a system where delays and costs are a major concern, even small improvements in efficiency can make a significant difference to litigants who are waiting for years, over generations, for resolution of their disputes. At the same time, it is very important to address some pressing concerns. There is a natural question: can such technology interfere with judicial independence or reduce the human element of justice? Justice involves empathy, compassion, context, and a deep understanding of human life. No machine can replicate that. Therefore, the principle must remain clear and non-negotiable. Artificial intelligence can only assist, but the judge must always decide. Unlike other sectors, errors in the judicial system do not merely cause inconvenience. They can affect life, liberty, and dignity. Therefore, introduction of AI into judicial processes must be approached with a deep sense of responsibility. There have already been instances where AI has produced incorrect or even entirely fabricated case law citations, even in the Supreme Court before my bench. A case was cited titled Mercy versus Mankind, which did not exist at all. A very interesting title though, Mercy and Mankind, very relevant for the court though. In another instance, a Supreme Court judgment was relied upon which did not have the particular quotation, but the citation was correct. This makes verification indispensable or else we would be compromising public trust in the institution. In view of the reliance being placed on AI in the course of dispensation of justice, I think the time has now come for the learned advocates who rely upon judicial precedents to also issue a certificate that the judgments relied upon are authentic and have been reported in the relevant journals. I was informed about a particular incident where one of the district judges in the city civil court had to deal with a bunch of judgments which were cited by the advocate. And the learned judge looked into those judgments and said that those judgments are not applicable to the case of the learned advocate who had cited them. When the matter went to the High Court, the first ground was that the district judge has relied upon judgments which are fake. Who has cited those judgments? Then the High Court should have asked who cited those judgments in the High Court. See, therefore, AI is good as an aid, but it cannot be misused or abused either by the bar or by the bench in arriving at a result. Equally important is the concern of privacy and data protection. Courts handle highly sensitive information, personal data, financial details, criminal records, and confidential testimonies. This raises the risk of data breaches, misuse, or unauthorized access. Strong safeguards must be in place to ensure that the dignity and privacy of litigants are not compromised in the process of digitization and automation. I'm sure my learned brother, Justice Narasimha, will give more information on this in the afternoon session. But I want to highlight a more broader philosophical concern about the human character of justice. Judicial decision-making is not merely about applying law. It involves understanding particular context, weighing competing values, and responding to the complexities of human behavior. There is a moral and empathetic dimension to judging that no machine can replicate. If technology begins to influence the process too deeply, there is a risk that justice may become overly mechanical, losing the human sensitivity that is essential to fairness. In the Indian context, we have already taken some initial steps towards digitization through initiatives like e-courts and translation tools. But there again, we have to be very careful. Translation cannot be literal. Leave granted. In the Supreme Court, we say leave granted. It's an order. It cannot be chutti swikar. Special leave petition. Khas chutti yachika. My Lord the Chief Justice, we have to be very careful in translating these words of art into other languages. However, the reality across district courts is different. Some courts have access to better infrastructure, while others continue to face basic challenges. Even fundamental judicial infrastructure such as adequate judges' chambers, proper sanitation facilities, including toilets for women, and essential spaces like infant care rooms remains inconsistent across regions and states. But I think that the Karnataka government has been quite generous in providing some kind of infrastructure for our district judiciary. At the center of this renewed system remains the judge. Let us not forget the judge, for he is in the center of the courtroom. He cannot be replaced, neither she can be replaced. The judge can only be supported. The principle that must remain absolutely unchanged in the midst of all the change is the rule of law. No matter how advanced technology becomes, the foundation of our judiciary cannot and must not shift. Rule of law is not a technical concept. It is a moral and constitutional commitment that ensures fairness, equality, and accountability. Artificial intelligence in this context must always remain on the periphery, as a tool, as an aid, as a support system, but never the core of decision making. The core must always be the human judgment, guided by legal reasoning, constitutional values, and a deep sense of justice. If at any point technology begins to replace human judgment, we risk weakening the very institution of judiciary that we are trying to strengthen. As I conclude, I want to return to what matters most, that is, judging and judges. AI must respect experience, discretion, and role of judges as guardians of justice. If judges begin to rely too much on AI, this can create a form of cognitive influence. AI poses a threat to human cognition by subtly shaping how humans process information and make decisions. It poses a threat to the cognitive autonomy of humans, and particularly judges. Therefore, the classical idea of judicial independence must evolve to include independence from undue AI influence. This means ensuring that judges have final control over reasoning, and that use of AI remains at the periphery at all times and at all stages. Judicial independence in the modern era is not just freedom from external power, but also freedom from algorithmic influence. The future of justice cannot be shaped by AI, but by judges only, supported by tools, but guided always by constitutional values, rule of law, and commitment to equity and fairness. There has been adequate increase in salaries and allowances of judges in the district judiciary, thanks to the Pay Commission recommendations being accepted by the Supreme Court and implemented by the state governments. But judges who are unable to live within their known sources of income and fall prey to greed and temptation must be weeded out of the system. I must add that judges must be free from influence from all external pressures and also from their own colleagues. Enlightened independence is when judges are independent of their colleagues. They must develop courage and independence. There cannot be any coordination in decision making. I repeat, please don't have any coordination in decision making. I do not wish to elaborate it, for you know what I am saying. A tainted decision by a judge is a black mark on the judge and on the judiciary itself. Hence, let us realize and be conscious of our duty to the litigant public and to the nation. I will also use this occasion to remind high courts that judges in the district judiciary must be protected and supported by the high courts in discharge of their duties by a fair consideration of their representations and the exercise of powers under Article 235 relating to promotions, postings, transfers, and leave. A fair, transparent, and responsive administration by high courts is essential to preserve both the independence and morale of judges at the district level. I must say that the fairness of the registry of the high courts while dealing with the district judiciary is equally important, for no judicial officer must feel that he or she has been left in the lurch only because the registry of the High Court is not taking necessary steps at an appropriate time to assuage their grievances. At the same time, there must be a consciousness regarding the increase of women in the district judiciary. Chief Justice, particularly in the Karnataka, we have sometimes more than 50% in the recruitments who are women. There must be safety, dignity, and enabling working conditions for women judges, especially in the district judiciary. Don't give itineraries, which are where they are called itinerary judges, to women judges when you can give it to men judges. This includes not just physical infrastructure, but also institutional sensitivity and protection against bias or harassment. Strengthening these aspects is integral to building a Nyaya Palika that is not only efficient, but also inclusive and secure for all its members. I thank each one of you for your kind attention. Thank you and namaskar.
Well, ladies and gentlemen, the technology can assist the judge, but it cannot replace the judge. Indeed, the judiciary should adopt AI with prudence rather than haste. Thank you, Honorable Srimati Justice B.V. Nagaratna, for a highly thought-provoking address. Thank you, Madam.
May I now request Honorable Shri Justice Suryakant, Chief Justice of India, for his inaugural address. Sir, please.
ಬಂಧುಗಳೇ ಸ್ವಾಗತಿಸಿ Honorable Shri Justice Suryakant, Chief Justice of India.
Shri Siddharamaiah ji, Honorable Chief Minister of Karnataka, my sister, distinguished senior judge of the Supreme Court, Justice B.V. Nagaratna, Justice P.S. Narasimha, Judge Supreme Court of India and Chairperson of the AI Committee of Supreme Court of India, my brother Justice Kumar, Judge Supreme Court of India, Justice Vibhu Bhakru, Honorable the Chief Justice of High Court of Karnataka, distinguished judges of the High Court of Karnataka, very respected former Chief Justices, former judges of the High Court of Karnataka and other High Courts, Shri Shashikaran Sethi, Learned Advocate General of Karnataka, Shri K. Arvind Kamath, Learned Additional Solicitor General of India, Shri Shanti Bhushan, Deputy Solicitor General of India, other law officers of the state and union government, Registrar General, Member Secretary, State Legal Service Authority, Director, State Judicial Academy, and other officers on the establishment of the High Court of Karnataka, officers on the establishment of the Supreme Court of India, domain experts, resource persons, learned judicial officers of State of Karnataka, Srimati S. Nagashri, President of the Karnataka State Judicial Officers Association, Sri Raghavendra Shettigar, General Secretary of that association, other office bearers, members of the State Judicial Officers Association, Civil and Police Department officers of the State of Karnataka, I believe some former judicial officers are also present here, very distinguished ladies and gentlemen, friends from media. There are moments in life of an institution when introspection becomes indispensable. A time comes when it must pause, not out of hesitation, but out of responsibility. When we are witnessing a phase of transformation impacting the administration of justice not only by doctrinal developments or legislative changes, but by deeper structural shifts driven by technology, artificial intelligence, and a society whose expectations of justice are evolving rapidly, I believe that the time to pause and introspect has arrived for the Indian judiciary. Although this conference is convened for judicial officers of Karnataka, the conversation we engage today necessarily travels beyond the geographical limits of the single state. The challenges we confront and the possibilities we explore are shared across the judicial landscape of India. Karnataka, by virtue of its institutional dynamism and openness to innovation, has often served as a guiding force. What emerges from these deliberations has the potential to inform and shape judicial practices across the country. At the foundation of the justice delivery system stands the judicial officer, as very eloquently explained by my sister Justice Nagaratna, my brother Arvind Kumar in their speeches. And that judicial officers, for the ordinary citizen, represents not an abstract institution, but its most immediate and tangible presence. For many, the trial court is the first and at times the only point of interaction with the judiciary. It is here that constitutional promises assumed lived meaning, and where faith in the system is either strengthened or eroded. This position demands for more than legal proficiency. It requires an awareness that every case carries within it a human dimension, often marked by vulnerability, barriers, uncertainty, and expectations. A judicial officer must therefore approach adjudication not merely as an exercise in applying legal principles, but as an engagement with realities. Empathy and compassion, as pointed out by Honorable Chief Minister, are not external to this role, they are essential to it. They assume and they ensure that justice is not reduced to a mechanical process, but remains responsive to the human condition it seeks to regulate. At the same time, the discharge of judicial functions must be anchored in discipline and dignity. My sister, Justice Nagaratna, laid rightly a lot of emphasis on it. The manner in which a court conducts itself, say its punctuality, its orderliness, and the tone it sets contributes significantly to public confidence. Sitting on time, maintaining composure in proceedings, and engaging with the bar and litigants with courtesy are not matters of form. They are expressions of institutional respect. Judicial authority is best reflected not in assertion, but in balance, firm in decision, yet measured in conduct. Equally important is an awareness of the broader social and cultural context within which disputes arise. The diversity of our society requires that the law be applied with sensitivity to context. A judicial officer must therefore be attentive not only to statutes and precedents, but to the realities that shape the disputes before them. It is this combination of legal understanding, human sensitivity, and institutional discipline that defines the true character of judicial functioning. It is upon the foundation that the credibility of the judiciary indeed rests. And it is this foundation that must guide us as we turn to the question of how technology, and in particular artificial intelligence, is to be integrated into the judicial process. The emergence of artificial intelligence presents both significant opportunities and serious challenges for the judiciary. Those challenges have been highlighted by my sister Justice Nagaratna, by Brother Arvind Kumar, and other speakers also. On one hand, AI has the potential to enhance efficiency in meaningful ways by assisting in legal research, streamlining case management, organizing large volumes of data, and reducing administrative burdens that often consume valuable judicial time. With structured and targeted training, judicial officers can effectively harness these tools to improve productivity and ensure that greater time and attention are devoted to the core functioning of adjudication. However, the adoption of such technology must be accompanied by a clear and consensus understanding of its inherent limitations. Artificial intelligence operates on patterns and existing data sets. It does not possess judgment in the human sense, nor can it engage with the ethical, social, and moral dimensions that frequently underpin judicial decision-making. The process of judging is not merely analytical, it is also reflective, contextual, and guided by constitutional values. An over-reliance on AI tools risk reducing this nuanced exercise into a mechanical output, thereby diluting the depth, independence, and integrity of the judicial reasoning. Equally concerning is the emerging phenomena of inaccuracies generated by such systems. My sister has already pointed out how fake judgments, how fake pleadings. Yesterday or day before, I just cautioned the newly recruited advocates on record also that they need to be careful in using AI in the matter of drafting pleadings before the Supreme Court. There have been instances of fabricated precedents, as already pointed out. These so-called hallucinations are not minor technical lapses. They strike at the very foundation of the judicial process, which rests on accuracy, authenticity, and trust. If left unchecked, they have the potential to mislead, distort legal arguments, compromise the quality of adjudication, and misdirect the outcomes. There is also the growing risk of misuse of AI tools to generate misleading pleadings, frivolous claims, or superficially convincing yet substantively flawed submissions. Such practices not only burden the judicial system, but also divert attention from genuine disputes that require urgent resolution. In an already strained system, this adds a layer of complexity that must be addressed with seriousness. I am happy that you have invited my brother Justice Narasimha, who has been working hard on understanding the nuances, the complications, and of course the benefits of AI. I am quite sure when he will speak and share his ideas and thoughts with you, so many issues will stand resolved. But ultimately, technology must remain an aid, not a substitute. The integration of artificial intelligence into the judicial process must be guided by principle of balance, leveraging its benefits to enhancing efficiency, while steadfastly preserving the human intellect, experience, and constitutional consciousness that lie at the heart of justice. As we navigate this evolving landscape, it becomes necessary to reaffirm a foundational principle, namely that justice is and must remain a human endeavor. It is shaped by reasoning, guided by values, and enriched by experience. No technological advancement can replicate the intuitive understanding and moral judgment that lie at the core of judicial decision making. The task before us is not to resist technological progress, but to integrate it in a manner that strengthens rather than diminishes the essence of justice. The judiciary must be technologically adept, yet philosophically grounded. It must embrace innovation, but without surrendering its human character. The judicial officers of Karnataka have consistently demonstrated a level of commitment and professionalism that deserves recognition. My brother Justice Arvind Kumar gave facts and figures, the data. I congratulate each one of you for achieving this landmark. Your diligence, efficiency, and openness to reform have contributed significantly to the strength of the justice delivery system in the state. In many respects, Karnataka has set standards that resonate beyond its boundaries. The work undertaken here reflects not only administrative competence but also a deeper commitment to the ideals of justice. It is this combination that positions Karnataka as a model for judicial functioning across the country. The deliberations at this conference will undoubtedly contribute to shaping practices that extend far beyond the state of Karnataka. Dear friends, the future of the judiciary will be shaped by its ability to adapt without losing its core identity. This requires a continuous process of learning, reflection, and commitment to excellence. Each judicial officer, through their daily work, contributes to this larger institutional vision. We stand at a moment of transition where the choices we will define the trajectory of judiciary for years to come. While our tools and methods may evolve, our fundamental responsibility remains unchanged, namely to deliver justice that is fair, accessible, and humane. As custodian of this responsibility, we must ensure that technology serves to enhance and not replace the human elements that define justice. The trust reposed in the judiciary is sustained not by words, but by conduct, by the quiet, consistent discharge of duties in courtrooms across the country. Having said that, I would also add few lines to say that please do not be afraid of AI. What do you do when a case with very complicated facts and complex question of law is placed before you? You apply little more mind, you spend little more time, you show your little more patience, and then you feel so happy when you decide such a case. So will happen with the AI tools when we will start using them carefully and consciously, ensuring that your judge sitting inside you remains independent and is not influenced by these technical tools. I wish the conference great success and trust that the deliberations here will shape a more responsive, efficient, and human judiciary for the future. All the best wishes to all of you. Thank you very much for inviting me, allowing me to share my views. Jai Hind, Jai Bharat.
Ladies and gentlemen, the Honorable Chief Justice of India, Honorable Sri Justice Suryakant, has called upon the entire judicial officer fraternity to exercise caution and at the same time be independent and think like a judge. Let's give a huge round of applause and thank the Honorable Sri Justice for a highly inspiring and motivating inaugural address. Bahut dhanyavad, sir.
Ladies and gentlemen, the Karnataka Judiciary.
A standing ovation for the CJI.
Ladies and gentlemen, the Karnataka judiciary has emerged as one of the progressive judicial systems in India in embracing technology while maintaining judicial caution. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಆಯೋಜಿಸಲ್ಪಟ್ಟಂತಹ ಈ 2 ದಿನಗಳ ಸಮ್ಮೇಳನದಲ್ಲಿ ಹೊಸ ಹೊಳಹುಗಳು, ಹೊಸ ಚಿಂತನೆಗಳು ಮೂಡಿಬರಲಿ ಅಂತ ಆಶಿಸುತ್ತಾ ಇದೀಗ ಉದ್ಘಾಟನಾ ಸಮಾರಂಭದ ಕಟ್ಟಕಡೆಯ ಹಂತವಾದಂತಹ ವಂದನಾರ್ಪಣೆಗೆ ಕಾಲಿರಿಸ್ತಾ ಇದ್ದೇವೆ. ಮ್ಯಾನ್ ಆಫ್ ರಿಕ್ವೆಸ್ಟ್ ಶ್ರೀ ರಾಘವೇಂದ್ರ ಶೆಟ್ಟಿಗಾರ್, ಜನರಲ್ ಸೆಕ್ರೆಟರಿ KSJOA, to propose vote of thanks.
ಹಾಗೇನೆ ದಯವಿಟ್ಟು ತಾವೆಲ್ಲರೂ ಸಹ ತಮ್ಮ ಆಸನಗಳಲ್ಲಿ ಆಸೀನರಾಗಿರಬೇಕಾಗಿ ವಿನಂತಿ. ಯಾಕೆಂದ್ರೆ ಆಫ್ಟರ್ ದಿ ವರ್ಡ್ಸ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ವಿಲ್ ಬಿ ಹ್ಯಾವಿಂಗ್ ದಿ ನ್ಯಾಷನಲ್ ಆಂಥಮ್. ಸೊ ಪ್ಲೀಸ್ ಬಿ ಇನ್ ಯೋರ್ ಸೀಟ್ಸ್.
Dignitaries, on and off the dais, distinguished guests, ladies and gentlemen. On behalf of Karnataka State Judicial Officers Association, it is my proud privilege and honor to propose vote of thanks on this august occasion of the inaugural function of the 22nd Biennial State-Level Conference of Judicial Officers. At the outset, I express our most respectful gratitude to Honorable Sri Justice Suryakant, Chief Justice of India, for sparing His Lordship's most valuable time to grace and inaugurate this occasion. His Lordship's gracious presence and inspiring address has truly enriched this occasion and will remain a guiding force for all of us. Thank you, my Lord. I extend our sincere thanks to Sri Siddaramaiah, Honorable Chief Minister of Karnataka, for kindly consenting to be the guest of honor and for extending generous support to this conference. His encouragement to the judicial fraternity is deeply valued. Thank you, sir. We are blessed to have amongst us today 2 honorable judges of Supreme Court hailing from our motherland, Karnataka. We are profoundly grateful to Honorable Srimati Justice B.V. Nagaratna, Honorable Sri Justice Arvind Kumar, Honorable Judges of Supreme Court of India for their continued guidance, encouragement, and for gracing this occasion with their esteemed presence. Their words of wisdom are a constant source of inspiration to all judicial officers. Thank you, my lords. We acknowledge the presence of Honorable Sri Justice P.S. Narasimha, Judge, Supreme Court of India. Thank you, my lord. I express our heartfelt thanks to Honorable Sri Justice Vibhu Bhakru, Chief Justice, High Court of Karnataka, for presiding over this function and for His Lordship's unwavering support and encouragement to the association and its activities. Thank you, my lord. A special note of thanks to all honorable judges of High Court of Karnataka, former judges of Supreme Court, former judges of High Court, Honorable Sri Justice Rajiv Shakdir, former Chief Justice of Himachal Pradesh, Dr. Pawan Dugal, AA expert, Advocate General Sri Shashikiran Shetty, Additional Solicitor General and Solicitor General. Thank you, my lords and sirs. I take this opportunity to place on record our sincere appreciation to the President of our association for her leadership, dedication and efforts in organizing this conference. Thank you, Madam. I respectfully thank Honorable Registrar General Sri K.S. Kumar for supporting us at all levels in shaping out this conference. Thank you, sir. A special thanks to all Honorable Registrars of High Court of Karnataka, the Principal District and Session Judges, Head of Units, and all Judicial Officers, retired Judicial Officers for their cooperation and valuable support. Our sincere thanks to Srimati N.V. Bhavani, Principal Law Secretary, Government of Karnataka, and officers of various government departments for their assistance in making necessary arrangements and ensuring the smooth conduct of this event. I also extend my appreciation to all the office bearers of the association and members of the organizing committee whose committed efforts have made this event a success. I thank all the distinguished guests, speakers, panelists, participants, members of the print and media for their gracious presence. Finally, I thank all those who have either directly or indirectly helped us in organizing this conference. With gratitude in our hearts and purpose in our minds, let us move forward to serve justice with greater resolve. Thank you, one and all.
ಕಾರ್ಯಕ್ರಮದ ಯಶಸ್ಸಿಗೆ ಸಹಕರಿಸಿದಂತಹ ಎಲ್ಲರಿಗೂ ವಂದನೆಗಳನ್ನು ಸಲ್ಲಿಸಿದಂತಹ ಶ್ರೀಯುತ ರಾಘವೇಂದ್ರ ಶೆಟ್ಟಿಗಾರ್ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು.
We request all of you to kindly rise for the national anthem. We request the dignitaries to kindly stay back for a photo with the office bearers of KSJOA after the national anthem. ಈಗ ರಾಷ್ಟ್ರಗೀತೆ.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you very much. I request the office bearers to kindly come quickly for the photograph with the dignitaries.
ಧನ್ಯವಾದಗಳು.
Ladies and gentlemen, the technical session will unfold immediately after the photograph, so please do not leave the hall in the interest of time. So request all of you, Dayavitu Anyatha Bhavasbardu, request all of you to kindly stay back in the hall as the technical sessions will start immediately.
There is a slight change in the schedule. We will now break for the tea considering the time constraints. We will break for the tea and immediately assemble within 15 minutes and start with the technical session 1. Slight change in the time schedule. We will now break for the tea. Request everyone to kindly rejoin within 15 minutes as soon as possible. Thank you so much.